Dr. Marcel Okpara, thank you very much for joining me on this Day Live, the Sunday talk show. Good to see you.
It's my pleasure, Dr. Bati. Happy Sunday. How is your family?
Same
it's my pleasure to be here.
Sorry, I missed the doctoral celebrations because I had to leave Abuja and move to Lagos. But
your own destiny is still waiting for you. Any day you come to Abuja, we'll host you.
Thank you very much. But very quickly, the judgment by Justice Umar, specifically on Section 29, Sub 1 of the Electoral Act and all those other sections relating to the powers of the INEC to provide guidelines and to determine timetable and all of that. 31, 32, 33, 82, 84 Sub 1 and also Section 98. The Court of Justice Umar ruled that INEC acted ultra vires and that INEC has no powers to vary what the main statute says via the route of regulation and guidelines, and it was a violation of what the substantive law says. Can you help us explain how that is a good point of law or not?
Dr. Badi, thank you very much. Dr. Badi, you know this thing more than I do, that you don't need to have a law degree for you to know that the supreme law of the land is the constitution. Now, after the constitution, you have the Act of National Assembly. After the Act of National Assembly, you have the rules of an institution. Dr. Badi, what do I mean? We have a Supreme Court Act and we have Supreme Court rules. The Supreme Court Act is made by the National Assembly, while the Supreme Court rules is made by the CJN. We have Court of Appeal Acts made by the National Assembly. We have the Court of Appeal rules made by the President Court of Appeal. We have the Federal High Court Acts made by the National Assembly. We have the Federal High Court rules. We have the FCT High Court Acts, the Acts made by the National Assembly, establishing FCT High Court and the FCT High Court rules. Now we have the CBN Act, we have the CBN rules, we have the Electoral Act, we have the Electoral rules. Now what do I mean? Once the Constitution take a position in any particular matter, the Act, if any Act that is inconsistent with that particular position taken by the Constitution, that Act will be in abeyance. Because it is inconsistent with the Constitution. That one is very primary. Then the rules of any institution, we call it the rules of the court, call it the rules of the any organization, cannot take over the act of the National Assembly. What do I mean? Now, the Constitution gave the INEC the power to make policies, rules. That is what the Constitution said. The same Constitution said that the INEC shall ensure the compliance of the Act. Mr. Constitution. Now, what do I mean? Now, INEC, for you to make your rules, for any organization to make their rules, for FCT High Court to make their rules, for CBN to make their rules, for Supreme Court to make their rules, they must take the position of the Constitution, they must take the position of the Act. If their rules is going to be inconsistent with that of the Act, the rules cannot take the position of the Act whatsoever. Now, INEC, having known that the Act has provided that for you to INEC to make any rule, they will look at the Act. Having INEC now taking notice of the fact that the Electoral Act has provided that all the political parties they have opportunity to submit their membership card 120 days before the election, which will be either September or October, thereabout. They shouldn't have made any rules. So, Honorable Justice Omar, though I have a lot of things against most of the judgments he has been given, but on this particular one, I can clap for him. He did very, very well. It's very straightforward. You cannot place something or nothing and expect it to stand. Are you now, is the INEC chairman, are they in conflict? Are they dragging power with the National Assembly? They derive their own power from the National Assembly. In fact, it's the Act, the Electoral Act that even established them. So they cannot make any rules that will contravene the position of the Act. That is the position. So that particular, there is no ambiguity, there is no confusion. It doesn't even need anybody to have a law degree for you to know it. So that particular judgment is a welcome development, and I pray that INEC should not even waste our taxpayers' money to start appealing against it. I don't think that it will be, it's a welcome development. That is my position. The position of the law anyway.
Yeah, I get your point. Basic principle is subsidiary legislation, other guidelines or regulations or whatever it is so called, cannot override the substantive law. But INEC is saying he's studying the judgment and that is likely to go on appeal. On what grounds, on what principle, on what basis do you think that INEC can insist on variation at the Court of Appeal?
Dr. Batu, once again, I have been opportune to see what INEC. Remember that what INEC is saying, that INEC was saying that they have their power under the Constitution. I don't know who is advising them for goodness sake. I think I should send in a memo to the INEC chairman by Monday.
No, but the same constitution gives INEC powers to, define its own guidelines, its own regulations. Is that where the conflict is?
Yes, now, Dr. Bati, are you now saying that INEC want to take over the power of the given by the National Assembly under the same constitution? Dr. Bati, when they say that you have the power to make a rules, just like as I explained to you, a CJN has a right to make a rules for Supreme Court and what do you call it, enforcement of fundamental right rules. FCT High Court, Judge CJ has the right to make a rules, but that particular rules cannot contravene the act establishing them. Understand it very well, Dr. Bati. You have been guiding us in this our profession, where maybe your articles which has been helping us in what we are doing. The act of the National Assembly cannot contravene the rules of the INEC, cannot contravene that of Act of National Assembly. Yes, you have their power under the Constitution to make a rules, make a direction on how the election should be conducted, but it must be fall in line with the act, that particular act. If their rules contravenes the power, the act, had it been that the Constitution said that yes, 7 days, and the act said 120 days, and the act had it been that the Constitution said 120 days and the act now said 7 days, you INEC chairman is expected to follow that of the Constitution, because that of the act contravenes the Constitution. But the Constitution did not make any time frame. The Constitution gave you the power to make a rules, and you expected to make the rules in line with the act. That is I think we should understand this thing. You should make it in line with the act. Why a rules contravenes that of the act? So be it. Okay, now, Dr. But let me just give you an instance. The act now said, I think 4 years, and subject to renewal. I'm talking about the appointment of the chairman. Can you now make a rules to say that it's going to be 30 years? If the rule said that you are going to do this, the act said that you are going to do this, you are going to change the act with your own rules. It can't stand. It is a nullity. It's ultraviolence. It's a use of power.
Okay, Dr. Para. The opposition parties have been jubilating. The PDP, the Labour Party, the ADC, even IPAC, the inter-political parties body. Now, what options are available to those opposition parties, particularly now that they are already conducting their primaries, and the May 10 deadline that was given by INEC had already, ousted quite a number of persons who will have been part of this primaries process. So what options are available to those aggrieved parties now?
They can change. Dr. But there is a subsisting order judgment of the court that has not been set aside. And that judgment said that you have a right to ascend. So all the political parties now have a right to start welcoming political party members. And when they are bringing in members should be registering. They can be sending it to INEC, because there is a judgment that said that 120 days, which will be in either August or September, thereabout. So they can be welcoming people. People that want to decamp, they can say also decamp, pending when that judgment is being set aside. And I pray that INEC should not even appeal against it, because I don't see the reason why Court of Appeal should not uphold that decision of Justice Umar. It's a very straightforward. So they have a right to change, to decamp. They have a right to political parties have a right to start welcoming people. Remember that they have submitted the list of the members in line with the INEC directives. Now that there is a subsisting judgment saying that what INEC did was wrong, by stopping people, by compelling people to submit the list of their members where people are still want to come in. So this particular judgment has created the open door. They can come in. But there is a danger there, Dr. Bat. There is a danger there. I want to say this thing with a low voice, because permit me to say that Nigerian court cannot be predicted. If probably you decamp people, and probably somebody who have not been your member, you allow them to come in, they now register and pick a form, because I learned that some people that lost their primaries and the destiny in the APC, they are now rushing to NDC and some other parties to join the party, and they also buy form and fill to contest their primaries. Now, if you emerge, and probably if INEC appeal against the matter, and the Court of Appeal set aside that High Court, that Federal High Court judgment, what will be the fate of that political party? That was the reason why somebody like Dr. Sam Amade advised his own party, NDC, that they should not welcome any new member. They should allow what they have submitted, let it be, until pending when the matter will get to Supreme Court and what have you. But my own position, my own opinion, I advise INEC not to appeal against that judgment. Let them just allow what is in the electoral act to stand. That is my position.
Okay, are you saying invariably that this judgment is merely symbolic?
No, you cannot say so, Dr. Bat, because it's not academic. There is a subsisting judgment, Dr. Bat. That judgment stands. So I think by now they must have served the CTC of the judgment to INEC. So INEC has no right, as we speak now, has no right to reject any substituted or what they supplementary list given to them by any political party, saying that there are some people that will just register, please accept this one as our members. INEC has no right to reject it, because one, there is no stay of execution. In fact, what are you even saying? Because the judgment is declaratory, it's not executory. So what are you even saying? So they don't have a right to reject it, pending when that particular judgment is being set aside. But we are not saying that you can't say that it's academics. It is a judgment of the court which has given all the whole political party, as we speak, power to start registering new members and submit the names to INEC. And INEC whatsoever has no right to reject those names, because if INEC rejects those names, they commit contempt of court, and the committee proceeding should commence against the chairman.
Okay, now straightforward question. So how will this affect ongoing primaries? APC has concluded its primaries as we speak. They are giving out certificates in Abuja. Tomorrow, ADC is going to have its own presidential primary. So what is the effect of this on processes that have been concluded or that are ongoing?
Well, I think the people that benefited from it are the opposition parties, NDC, ADC, and Labour Party, and what have you. So these are the people that are benefiting, because remember that APC, the ruling party, has concluded their primaries with respect to state house of assembly, governorship, and house of rep, and senate. So those people that lost, they are now trooping in, trying to register. And what we are saying is that it is to their own benefit, because one, they have not concluded their own primaries. So even as at yesterday, a party like NDC are still selling their forms, and the people that are coming are the people that just left APC and they start coming to this particular party. So it's an advantage to them. So the question there is that, what of if they come in Dr. But I want you people, I think you should repeat this your program again so that we can elaborate it. If they allow those people to come in, probably somebody who lost in APC, join NDC, get the ticket for Senate or Federal House of Representatives or Assembly, and continue campaigning. And INEC decided to appeal against it. And when INEC appealed against it, and the Court of Appeal now set aside that particular judgment, what will be the fate of that particular person? Dr. Mike, I don't know whether you got my so to me, yes, to me, I will advise those no political party should allow all those people. If you want to come in as a member, you are free to come in, but come in as a member to pick a ticket and take over this thing, and probably the Court of Appeal set it aside, it may stop the party probably record to declare that no, that judgment was wrong. Anybody who has decamped from this thing is a nullity. That means that the party will not have a candidate in that. What happened in Zamfara will not be applied. So to me, my own advice, nobody should alter what is established. If you want to come in, you can come in, but come and vie for any political position is risk. That's my own free level advice.
Okay, Dr. Okpara, in the last few days, we've been hearing about primaries, and we've heard about protests, disagreements, whether it's in the APC or it's in the ADC or it's in PRP, which has now cleared 3 persons, including former Cross River State Governor Donald Duke, to be part of the process. So what's your assessment generally? Because it looks like even basic counting of persons at direct primaries in the APC, they couldn't even get the counting right. We saw, officials jumping from 15 to 400, from 400 to 600. Is this an indication of the chaos that is to come? But it's not only in APC.
Honestly,
as we speak, APC is jubilating in Abuja that President Bola Ahmed Tinubu has won by a landslide, even if his sole challenger is an unknown quantity. My opinion. I don't know what your opinion is.
Yes, Dr. Bati, to be honest with you, Nigeria is becoming a political conscious. And you can now see that in Nigeria now, everybody, Mebola, Mebaro, everybody is now discussing about politics, and you can't remove it away because people have seen now that if you are not into political power in Nigeria, you are nobody. So, and it's not going to be business as usual now, and it's not even Uhuru. Other political parties that are laughing at the APC, saying that the APC is going to have problem in Rivers now that Fubara has lost. Fubara is going to play, is going to work against them. This person has worked, Omo Vega has lost. No, let us watch. But between now and let's say Monday next week, by that time all political parties must have finished their primaries. We know where they are going. I'm seeing a lot of litigations. It's not going to be business as usual, and I pray that opposition should get their ass together, because what is happening in APC, for if you should ask me as I speak, as I'm talking to you from the studio, being someone that has been following events, majority of members of APC, they are not happy because of what the governors did in various states. The governors use their position to settle their girlfriends, settle their loved ones, settle their destiny, and the people that felt that the other people that felt that politics is their father's inheritance, it is my right. You have gone the first one, you have gone the second one, you want to go the third one, and the governor now said to remove you. They said that they're going to work against. So it is neither there or there. So, but what I'm saying is that 2027 is not going to be business as usual, and any political party that did not front a popular, duly accepted candidate, they are going to find it difficult. Take it to bank, Dr. Bati, because Nigerians are angry. So nobody can predict what the politics is going to be in 2027. The only thing I can tell you is that nobody is interested. I said it here in the studio the other day. Politicians, majority of 90% of politicians are not ready to go to court. The issue of rigging and asking to go to court is not going to come up again because somebody is interested in court. They are going to fight it and sort it out today in the polling booth. So I don't know how they are going to do it. I'm pitying the security agents. So the best thing for INEC is to do the needful. So if you are trying to announce a result by 4 a.m. in the morning, my dear brother, it's not going to be business. So it may not be palatable. I leave it at that.
Yeah, but you are saying you expect to see a lot of litigation. But isn't it already settled?
Yes.
In Onoa versus Okafor, and also in Fubara's case, Fubara Dagogo, I don't know whether, isn't this settled that pre-election jurisprudence is of a different sort this time around? Are you advising people who want to go to court and...
No, that's another case. People are misinterpreting it, Dr. But with due respect. No. When you are, that does not mean that you don't have a right. If, pre-election matters used to be treated as internal affairs of the party.
Yes.
Plus, when your right is being violated, when your right is being violated, forget about, we are talking about fundamental rights. Dr. But you cannot just collect money from somebody and the person's name did not come out. You cannot collect money from somebody and say that the person has been screened out without telling the person the reason why you are screening him out. Because if you say that the person has been screened out and the person want to ask you, say that it's internal democracy of the party. No, because it has to do with somebody's integrity. Somebody can use it against the person. You should be able to say, my brother, we have checked your documents. Your document did not meet up a criteria, a standard set in by this party. And we are hereby screening you out. If you are saying that, please, I'm screening you out because I don't like your face, because I don't like the way you normally laugh, the person will go to court and challenge it. So the issue of internal affairs of the party, people are misinterpreting it. It's not when your right is being violated. You go to court to challenge it, and court will listen to you. So that one, and they say people, I have seen a lot of people singing it as an anthem. I said no. You people should read it very well. And moreover, majority of people, when they are approaching court, they normally approach court from a very wrong angle. When you approach court from an angle of your right to belong to an association has been violated, you are able to establish the grounds. Court will listen to you. The issue of internal affairs of the party should not even come up. Fair hearing.
So you are saying that Google versus APC does not apply because Onoa versus Okafor is a 2003 case, I think, or is it 2023? But the extant one is Fubara Dagogo versus APC. Again, about internal affairs of the party. Yes.
Dr. Bat, it depends on what you ask the court to do. What are your prayers? What are your grounds of approaching court? If your grounds of approaching court has to do with something that has to do with internal affairs of the party, court will tell you that no, this particular thing is internal affairs of the party. But if it has to do with the breach of the constitution itself, the breach of the constitution that established political party, have you forgotten that is the breach of the constitution that established electoral act? Is the constitution that also established political party. So when you are not saying that this is the breach of the electoral act and you join INEC, then court will now look at it from that particular angle. I think, Dr. But I pray that you have a particular time so that we'll be able to distinguish between what is the internal affairs of the party and what is a breach of the law. So that we'll be able to distinguish it. Because the issue of a political party using that particular thing as an epitome of fraud, defrauding people, violating people's rights, intimidating people because of the national chairman has interest in the particular thing. He said go to court. After all, it's internal affairs of the party. Should not even come up because the party is expected to act in line with the establish the constitution of the party and the electoral act and the constitution. So that is, I think you should please, Dr. But I pray that you create even if it's for 5 minutes, so that people will be able to establish to people, so that people will know when even the political party, even the INEC, even the court should know that when a matter comes up, this particular one has nothing to do with internal affairs of the party. It has to do with the law. And the law is made to be obeyed, and it should be obeyed.
Okay, on that note.